Member for Timmins James Bay.
Thank you, Madam Speaker. As always, a great honor to rise in this House on behalf of people of Timmins James Bay. And I'm today particularly thinking about the Cree communities in Upper James Bay, Attawapiskat, Fort Albany, Peawanuck, Kishechuan, Moosonee Moose Factory, plus people who's been spread across Canada, and all of them go back to a horrific institution called St. Anne's Residential School. And I think it's important, as we're talking about the Act to amend the Judges Act, to reflect that we just saw one of the darker decisions from the Supreme Court, the refusal of the Supreme Court to look at the miscarriage of justice that was committed against the children at St. Anne's, giving no reason, no explanation. I think when we talk about amending the Judges Act, I think of a great parliamentarian, Rona Ambrose, who spoke up about the need for judges to get basic and legal education in dealing with sexual assault, because we've seen a number of really, really bad decisions, and they've been referenced here. But I think it's also important that our judiciary needs to understand the findings of the Truth and Reconciliation Commission and the obligations of Canada, and that includes the courts, to address issues in terms of the equity and the rights of Indigenous people. Because if you look at the cases of St. Anne's Residential School, it is clear that any Indigenous person looking at this would wonder, how is it possible to get justice in Canada? It's not a complex issue. I'll talk about a really powerful woman, Evelyn Korkmaz, who suffered horrific sexual violence as a child at St. Anne's, and the collusion of the Grey Sisters, the nuns, who covered it up. When she went to the hearings to tell her story, the first thing the adjudicator told her, he said, "I'm a proud member of the Knights of Columbus." They were there to adjudicate crimes against the Catholic Church, and the first thing she was told by the adjudicator was that he was a member of the Knights of Columbus. And then he said to her, "I know the nuns of St. Anne's. I know that order. They're good women." She said she knew right then that she wasn't going to be believed. Now, in any other court process, that case would have been thrown out, but not in the Indian Residential School Settlement Agreement. And one of the reasons the adjudicator didn't believe Evelyn Korkmaz's story of the horrific sexual violence was because the other defendant in the case, Canada, had the legal obligation in the hearings to prepare the evidence. And the adjudicator looked at the evidence supplied by the Justice Department of Canada that said in one line, "No known incidents of sexual abuse at Fort Albany Indian Residential School." What they didn't tell the adjudicator was that the Justice Department had 10,000 pages of police testimony and witness names of rape, torture, violence, forced abortions against children in that evil institution. I think of this man, he goes by the name of H15019. He suffered horrific sexual violence, and he went into the hearings to expose Father Lavoie. And the Justice Department lawyers said, "You're not believable, because Father Lavoie was not in the institution when you claim he was." And as proof, they presented a 2-page person of interest report, which was their legal obligation, on all the known potential perpetrators. So a 2-page person of interest report said Father Lavoie wasn't there. What they were sitting on at the Justice Department was 2,472 pages of a sick, evil man who through 4 decades raped multiple generations of children. And the case of H15019 was thrown out. And when they tried to have this case reopened, the Justice Department and the federal government forced this case to the BC Superior Court, although this happened in Ontario. Now, why would they do that? Well, they did that because they knew that the survivors didn't have the money to go to BC Superior Court. How could you claim that this was a just process? What happened in that case was that after the Justice Department decided to suppress the evidence, then they decided that they were going to shut the hearings down and they were going to deny justice. This is not a very complex issue. 10 years, through multiple legal battles, this went on. And finally, Parliament had called on this government that they had to settle with the St. Anne's survivors. So the former minister sent on March 18th, 2021, a request to have the cases of St. Anne's reviewed. And we thought, finally, justice. That's all the survivors wanted. They wanted to review what had happened with the suppression of evidence. But if you read the report, the request for direction sent by the federal government, they didn't ask the courts to review this to get justice for children whose rape and torture had been suppressed. They did this because they said people speaking up about St. Anne's was making the government look bad. It's right there in their request for directions. And do you know who they blamed for making the government look bad? Senator Murray Sinclair. Because he said there can't be reconciliation without justice for St. Anne's. Dr. Pamela Palmatier, who raised issues about what happened at St. Anne's. Edmund Matatawaban, the survivor of the abuse, who speaks for the survivors, his name is in the government request for directions that he is making the government look bad for the abuse he suffered. And interestingly, of course, I'm in there for about 30-some pages, but I don't mind that. But Osgoode law professor Jennifer Leach, she was named by the government of making them look bad because she wrote, "The government's non-disclosure raises significant concerns about the scope of information available to the adjudicators, the claimant's ability to establish abuse allegations, and the scope of the compensation." Professor of law said this is a flawed process. So the instructions given to Justice Pitfield to look at this excluded many of the horrific cases. And he was not to talk to the survivors. What kind of justice system is that? So he examined 427 cases, and he came back in his preliminary and said 81 at least serious need for re-examination. That's 20% of those cases falsely adjudicated. But then in the final report, he said, no, it was just 10. Student on student. No blame to clergy, no blame to staff, no blame to government, no involvement with survivors. So of course the survivors took this to the Supreme Court. But when I talked to the survivors yesterday about the fact that the Supreme Court wouldn't hear their case, they said they weren't surprised because this was never a fair fight. They went with pro bono lawyers. There were days they couldn't even afford their own bus fare to get to the hearings. And yet Canada spent millions of dollars on lawyers to shut this down. It was never a fair fight. And this is why I refer to this when we're talking about Bill C-9. I'm not questioning the wisdom of the Supreme Court, but I am questioning the lack of understanding of the obligation in this time to understand the obligations under the Truth and Reconciliation, to say that we have a higher level of justice to attain here. Because one of the fundamental arguments of the government was that the survivors were not entitled to procedural fairness. Procedural fairness has been ruled by the Supreme Court as a fundamental right. And what they meant was, well, just because we didn't bother to supply any evidence and just because we lied in hearings, that's okay, because the survivors are not entitled to the basic principle of procedural fairness. And if you look at the evidence that the government brought forward as to why procedural fairness wasn't right, they put it under sealing orders so people couldn't see that. What is this? Soviet-style justice? Phil Fontaine, who signed the Indian Residential School Settlement Agreement, wrote that they would never have signed this agreement if they were giving away fundamental legal rights under this process that gave them less rights than they would get in court. And of course, Canada ridiculed Mr. Fontaine's response and said that this issue of procedural fairness was completely irrelevant. It is completely relevant, Madam Speaker. So on this day, the day after, the Supreme Court has shrugged and said, well, whatever happened at St. Anne's, whatever happened with judges who misread the reports because they were lied to by the Justice Department, whatever is said about perpetrators of horrific abuse, and we have many of their names, Bishop Laguerriere, André Lavoie, those men got away, and the survivors are still living with injustice, and they deserve better in this country. They never asked for huge compensation. They asked this government to sit down and recognize that what was done to them was one of the most horrific, evil acts ever committed against innocent children. And those innocent children have had their legal rights undermined time and time again by a system that wanted to shut this process down. So if we're talking about amending the Judges Act, we have to look at what happened at St. Anne's and why there was no understanding on the judge's part of the need to hold this government and the Justice Department of Canada to account.
Questions and comments? Questions et